I guess I'll just have to do it from my phone.
Oh yeah, no, computer doesn't allow.
Hi. Is that the fight?
How are you doing?
Do it from my computer. But
Sorry.
I guess I'll just have to do it. Let me just switch all this off. I'm fine. How are you?
I'm like, why am I hearing this again?
I know. Made me feel crazy too.
How is everybody doing today? Good, 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 good. Thank you for my lipstick comment. Thank you so much. This is the only thing that I love about like winter is we get to do the dark lip thing. I hate everything else about winter. Welcome, welcome everybody. Okay, I think we can get started. So, Kgomotso, thank you so much for joining me for this conversation. So, for those of you who have not interacted with Kgomotso or not following her on social media, she is a labor law lecturer, and she's also a PhD candidate, ma'am. I mean, do you not have academic fatigue?
Emphasize candidate, please.
I mean, I'm tired for you.
I'm tired.
I can imagine. So I wanted us to have this conversation today because I obviously am constantly having workplace related conversations and engagements with people, and there's a lot of questions that come up around very specific employee rights type of issues. And so, I mean, we met at an event last year, and you know, obviously was just like, there's only one person who'll be able to address some of the questions that come up quite often. So if you do have any questions, please do put them on just put them in the comments. We'll go through them as we go, but just to get us started, I'll ask some questions just from the generic stuff that I've kind of been getting, you know, over the past year or so, just to kick off the conversation.
Sure.
Okay, and guys, please also let me know if you have any issues with the connectivity or the network. I know I had a bit of an issue with that on Sunday, so please let me know if you have any of those issues today. Other than that, okay, let's get this started. So, when you're joining an organization, obviously the first thing that you interact with, other than going through the recruitment process, is the employment contract. And for many people, once we get that contract, it's like, oh, got the offer, gonna sign, got the job. I know it. The only thing we look for is the amount of money that's on there. And perhaps we might look at our working hours, just a glance. And you know, we just sign on the dotted line. But what are some of the things that people actually underestimate about the importance of going through your employment contract in detail?
So the most important thing, to be honest, is that you must know that even if you've got an employment contract, the labor law really takes precedent over an employment contract. So even if there's something stipulated or not stipulated in your contract that should be there and isn't there, it doesn't mean it doesn't apply to you. So it's you know, I often tell people there's no real need to necessarily be married to a contract insofar, unless it relates to things like your salary, your benefits, things that you really, really want. Those are really the most important things for you to look at. But over and above that, you have protection that comes from the existing labor law legislation. Whether it's written there or it's not written there, it exists. There are some aspects that will not apply if you earn a certain amount of money. It's about over 205,000 rands, just about, per annum. So if you earn more than that, there's certain things that don't apply to you. For example, working hours. That's why they can get away with making us work all the bajillion hours. So because you earn a particular amount of money, there's an expectation that you will, of course, work more than 8 hours a day, which is unfortunate, but that is a reality in most sectors, especially in corporate for the most part. Yeah.
Now, I was going to save the working hours question for a bit later in the conversation, but now that you brought it up, this is obviously coming up a lot, especially now that we're in lockdown, because, you know, employers are seemingly putting pressure on employees to be accessible and available at all sorts of crazy hours.
Yeah.
Where do we draw the line? I mean, it's one thing to say, have the flexibility to work outside of the 8 hours, but when do employees get an opportunity to say, okay, no, we're not doing this. This is
You
great.
know, and I'll be honest with you, it's very difficult to draw the line. One of the things that I try and encourage people to do is to start early on. So, the very first time your boss calls you at 9 p.m., don't pick up the phone.
Mm.
Set the tone. Set the tone. Create that dynamic that says, I won't answer the phone at this time. But you must understand that there are underlying consequences of that. And the difficulty is that where you don't answer the phone, there's always going to be somebody who answers
Yeah.
who answers the phone. And that's sometimes the challenge, that employees don't stand together. Employees don't operate collectively. That's why there's such benefits in things like trade unions, which those of us who are high income earners tend to avoid.
Yeah.
We don't bargain collectively. We don't engage collectively. So where Sihle says, I'm not going to pick up at 9 p.m., there's Kgomotso who's like, I got this, don't worry.
Yeah.
and I
Because
and
you want to be the standout employee.
I want to be the steering. I want to be the steering there.
Mm.
And I can see Sihle is not about that life. I'm about to be about that life. So
Mm.
that's the difficulty, and why things like collective bargaining are so important, and generally collective engagement with your employer, even if it's outside of a trade union, even if it's some sort of a workplace forum, or collective, generally speaking, it's better than you interacting with your employer as an individual, because these types of tensions arise.
Absolutely. And these tensions, are increasingly leading to more and more employees suffering from various different mental health issues at the moment. We're seeing a spike in, issues like anxiety and stress, burnout, people getting checked into, psychiatric institutions.
Mm,
Um, Employers are now starting to speak a lot more openly about employee benefits, and one of those things is always like a platform like an ICAS or a whatever the story is, that's supposed to be a support benefit that is available to
mm,
employees if they need emotional or mental support or whatever the case may be, and that's part of the value proposition for employees. But a lot of people have expressed that they are concerned about using those types of platforms that are kind of provided by the organization, because they're concerned about the protection of their personal information,
mm,
because if it gets into, if they employers find out, and they're afraid that they're going to be discriminated against in some way, or
mm,
if employees get booked off by a doctor and checked into a psychiatric facility, they are concerned about how that's going to impact on them when they get back into the workplace. So how
mm,
can people manage that? Because some people obviously are, there's one particular woman who had the situation where she was checked into a facility. When she got back into work, she was treated as if she's incapacitated.
yeah.
She was no longer allowed to fulfill her role. She was looked down upon. She was treated differently. She was excluded and sidelined, and eventually worked out of the organization. So how
So
can people navigate that?
yeah. So I mean, the first thing is, I think one thing we've all got to reckon with, unfortunately, if we are going to be employed, is that for the most part, employers tend to have an upper hand in lots of aspects of the employment relationship.
Mm.
So there is a risk that you use something provided by the employer and it comes back to bite you.
Mm.
In the specific instance where an employee, for example, if I seek psychological or psychiatric help, perhaps through the employer, and I later feel victimized, we've got a different thing on our hands. Now we've got a question of unfair discrimination.
Mm.
So if and that is something that you can deal with internally and then externally with the CCMA. So where an employee believes or is under the impression that they are now being victimized or discriminated against based on some assistance that they might have sought, or maybe it's them just being open with their employer, even if they didn't use the employer's facilities, if they were just
Yeah.
open and said, look, this is what I'm going through, this is what I want you to know, and then they later start to feel sidelined, that is something that an employee can deal with through a grievance procedure and then through the CCMA if they're not successful internally. Um, an employer, at times, they do begin to use, and that's the unfortunate thing. You will find employers who will use mental illness as a way to deem you to be incapacitated and dismiss you then subsequently for incapacity,
Mm.
or constructively dismiss you and make you,
Mm.
push you to a point where they know you will resign. So that does happen. That does happen. what I often say to employees is really do not resign. Let them push you out, let them dismiss you. But as a start, before you even get to that point, if you start to think that something is wrong in terms of the way you are being treated and you believe it relates to your mental illness, it is something that you can lodge a grievance against first and exhaust your internal remedies, and then go to
Mm-hmm.
the CCMA and lodge a referral relating to unfair discrimination.
Okay,
And that's
perfect. So
before
for
you've left the employment.
Okay, perfect.
Yeah.
So for the people who don't know or have never heard of the term constructive dismissal, could you please explain that to them?
Okay, so constructive dismissal is when an employer creates an intolerable working environment, so intolerable that you believe your only option is to resign. So now I need to make this very clear. It's a very high mountain to climb to demonstrate constructive dismissal. It is not something where we fought, you and I have an argument today and I say, I've had enough of her, I'm done, and I leave. That happened one time. That's not going to cut it. So it needs to really, unfortunately, you really, really need to be at the end of your tether, and you need to have tried to. You really need to be able to show that you've lodged grievances. If I feel, for example, that I'm being bullied or I am being worked out or somebody is harassing me, I must lodge grievances internally, and those grievances must lapse. People must not
Mm-hmm.
do anything about those grievances. I feel like I'm getting no joy from the internal processes. I've gone from pillar to post, and then I resign because I've got no other option. Okay. Sometimes employees will give a month's notice and then say the environment is intolerable. It's not. You can work there for 4 more weeks. It's not. It's not intolerable. But people will try all kinds of things because they actually want to keep their job. They want to resolve the dispute, so they tend to stick around a little bit longer.
Mm.
But it's really important for a constructive dismissal claim to succeed that you've really, really, really got to be at the end of your tether, and you need to have exhausted all internal remedies at your organization.
So now the challenge with that is that for so many people, especially Black professionals, you know, getting to the point of being at the end of your tether has got to take a hell of a lot, because we're always thinking about, but I have bills to pay.
Yeah.
I have all of these responsibilities. And also we understand corporate politics and all of these, institutional structures that exist. So even if I'm an employee and I'm going through this horrible experience within the workplace, I go through all of the grievance processes. They know the law. They have all of the best lawyers available to them and internal departments. So they know all of the right boxes to tick. So,
Yeah.
I might be lodging all of these grievances, but each and every single outcome is, in the favor of the employer. And then eventually I decide to up and quit, and they can say, well, the grievances were filed, we dealt with them, none of them were, they didn't lapse, and so we're well within, it's got nothing to do with us if they decide to quit their job. How do we deal with just the insidiousness of that with regards to corporate culture and their ability to cover their tracks?
I had a discussion earlier on with a colleague about this very issue, because the labor law and the realities of law is that there is an evidentiary burden attached to every allegation one makes. And as much as, and I mean, this happens a lot, especially when you're talking about issues of racism, sexism in the workplace, homophobia in the workplace. It is very insidious. It's very hidden. It's an underlying sense that something isn't right. And it's extremely difficult to demonstrate. Where, practically speaking, when you have grievance processes that have, been exhausted, as in you've dealt with them and they don't go in your favor, it does not mean you cannot still go and lodge a claim externally, because you still have a concern, and they will have to come and demonstrate the genuineness of those processes. Because even, I mean, of course, externally, outside of your organization, the CCMA, the law understands that an employer is going to call, their buddy from somewhere to come and chair your hearing. And they know, and I mean, unfortunately, there are people who chase the work. They will rule in favor of the employer, even if the employer is wrong. That does happen. So the law does protect you in that sense, that the employer will then have to come and demonstrate the reality and the truth of what actually happened in those grievance processes, and if they genuinely try to address your concerns. But one of the very most important things that people can do from day one is start to collect evidence, documentary evidence, record your meetings, confirm emails all the time. When you have a verbal conversation with someone, confirm it in an email, no matter what it is. Let them come back and deny it and say, I never said that. But they probably won't. But rather confirm it, to say, I confirm that the conversation we had earlier today in the lift about X, Y, and Z, we said this, this, and this. Thank you. Kind regards. That's all you've got to do. Create a folder for yourself. And I don't say people must be paranoid and constantly collecting evidence, but you know when something is not right between yourself and somebody else within the organization. At that point, start to keep an eye on your communications with that individual.
Now, for a lot of people, this issue of cover your ass obviously is becoming more and more prominent for us as Black people. We're starting to pay more attention to that and keeping a paper trail. But obviously it's important to understand what the confines of your employment contract and keeping your paper trails, with at work, and what that then means for you in terms of your being able to use that information or access it. How important is it for people to make sure that they keep their evidence off-site?
It's hugely important, because I mean, as soon as you are suspended, for example, there goes your access to your emails. So blind copy your personal email address. There's nothing wrong with that. It's your correspondence. So there's nothing illegal about you blind copying your own correspondence with someone. There's nothing illegal about you collecting screenshots. There's nothing wrong with that. Many people get to the CCMA and they come with screenshots of WhatsApps, emails, all kinds of things. It's very important, actually, if there's a problem, if you see that there is a problem, to make sure that your correspondence and your issues go somewhere else, that you can keep them safe. Because if you are suspended, I mean, you don't have any control over that computer or the access to your emails. You won't have any control over those things. So that's critical.
And what about recordings? Do you have to let the people know that you're recording? Or can you
No.
privately record, and how can you use that evidence? Are the limitations?
So you can privately record. You are allowed to record your own conversations with others. So if I find myself hearing or overhearing a conversation between two other people, I can't record that. That's not a conversation that I'm having, right? So as long as I'm in the conversation or in a meeting, many people, for example, when there's a retrenchment process, they record the Section 189 consultations. There's nothing wrong with that. You can do that. When you get to the CCMA, normally they will ask you to file a transcript of the recording. So it's not that they would necessarily want to hear it. They want to see it written down and admitted into evidence. They might say, okay, for the benefit of us knowing that it's a real recording, you can play a little bit of it, but they want to see a transcript that they can refer to. That is the way you would present that evidence later on.
Okay, that's what I did. Because I recorded all my conversations and everything was transcribed. That's why I was able to write a book. That really helped me a lot. Made life so much easier.
Important. Yeah.
So you mentioned briefly around Section 189s, which is retrenchments. With everything that's happening right now, obviously retrenchment is something that's happening in some organizations. It's something that a lot of people are very concerned about, because there's a lot of uncertainty about when do we get back to any kind of normalcy? What does the economic future look like for businesses and for employees? What are some of the things that people need to know about retrenchments and just that process that needs to be followed by organizations?
So what's really important about, I mean, the retrenchment thing is troubling me late at night, to be honest, because I find that it is, in my opinion, a little bit too easy to retrench. And that is going to be something that is standard procedure from for now, for maybe the next 18 months. We're going to see a lot more retrenchments. In terms of what it needs to happen, the first thing that kicks off a retrenchment process is what we call a Section 189 letter. Section 189 makes reference to Section 189 of the Labor Relations Act, which sets out the process for retrenchment. Now, that letter, if it is genuine, is supposed to be an invitation to consult. Okay, so it is an invitation to employees to say, we are considering retrenchment. This is what we've already thought of, but we need to invite you to a series of consultations so that we can jointly reach consensus. Okay,
Mm-hmm.
and consensus needs to be, well, so this is the difficult part for me on 189. The employer only has to demonstrate that they attempted to reach consensus.
Ah.
Attempt attempt so if they don't actually reach consensus, they are entitled to make a decision, but they must demonstrate genuine consultation in an effort to try and reach consensus, which to me isn't good enough, but
Mm-hmm.
but that is the reality. And consensus will be on things like, what will the severance packages be, the timing of the retrenchment, is there going to be any training offered to employees to try and upskill them, that sort of thing, those sorts of benefits, or is there possibility of reemployment at a later stage. So
Mm-hmm.
those are the types of things that the employer must negotiate on. Employers often offer voluntary severance packages. So they
Mm-hmm.
will say, look, who is done, they happy to leave the company, they just want to pay out, they're ready to go. Employees are more than welcome to take those packages. It can be, if it's fair, it can be hassle free, but there's no obligation to take it. Employers sometimes try and find alternative employment for an employee. If you refuse reasonable alternative employment in a retrenchment process, you will be denied the severance package. So if your employer finds you a reasonable alternative to work, you will not be entitled to the severance package if you refuse the work. That's very
Mm-hmm.
important. And the last thing that's really, really important is the entitlement to severance in law is 1 week for every completed year of service. Okay. And
Mm-hmm.
that is, a lot of people refer to that as long service. They think it comes with every kind of dismissal. It's not every kind of dismissal. It's only operational requirements or retrenchments. And
Mm-hmm.
it's only 1 week for every completed year. If your employer offers you more, it's just fortunate. But
Yeah.
that's all they have to offer. Yeah.
Question here from Tabitha is, what would be the advice if South African nationals want to establish their own staff union?
What do you mean? Like alone?
Like if we just like, okay, sharp, let's do this, guys. You know,
Alone, without the
like
party.
when we get off this IG live, we're gonna start the paperwork.
No, Erks. No, guys. There's no, look, you can't discriminate in terms of your membership of a trade union. There's no trade union that can justifiably discriminate its membership based on citizenship. So forget about that. That's not gonna fly. And you better off, ultimately, you better off negotiating collectively. That's the reality. And as much as I don't know why there's this idea that blacks outside of our borders are different kinds of blacks. We're all the same, guys. And, and a lot of the things are, I know there are things that are happening that people perceive to be related to citizenship. That's not what it is. This
Yeah,
thing is about divide and conquer. Let's not allow
yeah,
ourselves to be divided. So forget about
absolutely.
that thing.
Absolutely. Now, one of the other things that is of growing concern is around the issue of HR policies, right? We all know how vague policies within the workplace are and can be. Like, for instance, an organization might say, we don't tolerate bullying, but don't actually detail what they consider bullying. Or they
Yeah,
might say, we don't tolerate sexual harassment, but won't detail that. And so when you come in as an employee and you want to file a claim, you literally don't know, what behaviors you need to be communicating in order for your claim to be successfully investigated and resolved. So
yeah.
how can employees begin to navigate that? What type of
So,
conversations should they be having with their employers?
so as much as it would be great and to assume that the conversation with your employer will be successful, they're going to do what they want ultimately.
Mm.
So, but what you've got to know is that in the absence of a policy, there are codes of good practice. There are codes of good practice that the employer ultimately, that is what the law considers. If there's no policy, if the policy is silent on a particular issue, there are codes of good practice that the CCMA or the Labor Court or the Labor Appeal Court will consider in the absence of clear policy. And now something like bullying or harassment, I mean, that's set out in the Employment Equity Act, exactly what that constitutes. and it is a form, we consider it a form of unfair discrimination.
Mm.
But ultimately, what employees need to know, and those codes of good practice are available online. You can Google the code of good practice relating to what HR policies should say, dismissals. There's various codes of good practice that anybody can just Google, look it up online. They are there, and those are the things that whether or not your employer has stipulated them in a policy, they apply to you regardless.
Okay. Now, discipline and misconduct. So, whenever I have these conversations around the experiences of Black professionals in the workplace, I often feel like I have to include a side note, a PS that says, as much as I'm speaking for Black professionals in the workplace, this I'm not speaking for people who are intentionally causing havoc in the
Yeah.
workplace just because they happen to be Black. Let's
Yeah.
just be clear. Like, you've got to actually be doing your job.
Yeah.
You've got to actually be ethical.
Yeah.
Like, it's not
Please.
just because you're Black, or I'm out here for you. No, I'm not
Yeah.
riding or dying. Okay. So, um, what are some of the ways in which misconduct can be addressed within the workplace? Because some people, might do something wrong, might have some sort of misconduct, and then be like, oh my gosh, my organization is so unfair to me. Social media,
Mm-hmm.
you go and you tweet, fuck Black people. And
Yeah.
then you're like, what about my right to freedom of speech, all of these crazy things. So
Yeah.
what are some of the ways in which organizations address misconduct in the workplace?
So the way an organization must address a misconduct in law is that they need to investigate the misconduct, okay, as a start. So they would notify you. There's an allegation in this that relates to X, Y, and Z. We see it's alleged that you posted this on social media, right? We're going to investigate this thing. They might place you on precautionary suspension. Sorry, my battery is dying. Such a suspension is a paid suspension. So if your suspension is relating to investigating a misconduct, it's paid. It's not a disciplinary measure at that point. So they would investigate perhaps with you not at the workplace, and then they would have a disciplinary hearing. At the disciplinary hearing, you must be allowed to speak, tell your version of the story, apologize, whatever it is you want to do. You must be allowed to do that. If you need representation, you must be allowed to bring representation with you. You must be allowed an interpreter if you feel that you're not going to be comfortable in the language that everybody else is using. And then the outcome of your hearing must be given to you in writing. Now, in terms of a sanction, so let's imagine you're found guilty, okay? In terms of a sanction, they might choose to dismiss you. Whether or not a dismissal is too harsh depends on a few things like your length of service. Have you committed a misconduct like this before? How serious is the offense you committed? What is the nature of your work, right? Those are the types of things to consider whether or not a dismissal is appropriate. Another type of disciplinary action might be a suspension, a disciplinary suspension to say, you're not going to work for a month, we're going to dock your pay as a result, or whatever the case may be. Or it can be a warning, a final written warning. Those types of things are appropriate sanctions, and it just depends on what the circumstances of the dismissal are.
Representation.
I beg your pardon? Please say that again. You disappeared for a second.
I wonder. Yeah, there was a bit of a freeze there.
Yeah.
I want to talk a bit about representation when you are
Yeah.
going through, misconduct or grievance issues or whatever the case may be. For a lot of organizations, they say that if you are going to bring a representative, it must be somebody who works within the organization. But we all understand the dynamics around that, because
Yeah.
oftentimes no colleague of yours wants to represent you because they don't want to then be painted with the same brush, or
Yeah.
to be victimized as a result of that. So how can employees navigate that?
So it's something that an employee can certainly apply to say, look, I want to be represented by someone external. And if it's later found that it wasn't fair for the employer to deny them an external representative, then that is something that could be raised later as a problem with procedural fairness of the dismissal. So it's something that I would say an employee must try and do if they believe that there's nobody in the employment space who can adequately represent them. An employer might say no, but that will then be a grounds later to say, actually, I don't believe this dismissal was procedurally fair because I requested a representative. My representative was available. There was nobody else that I felt comfortable with representing me. And I told them that. Perhaps I told them in writing. Perhaps I told them more than once. And they proceeded. They proceeded to ignore my request. So that's something very important to do.
Okay. Ole is asking, when an employee decides not to sign a warning, what then is the recourse?
I don't know why people do that thing of not. A warning is there, whether you sign the warning. The warning is the warning. The only what you can do if you don't agree with a warning is then bring it to the CCMA to say, I believe this is an unfair disciplinary practice. I want this warning overturned, and that happens often. So a lot of times, sometimes people will get to the CCMA and say, they gave me, they'll have like 5 written warnings or something crazy, and then they say, I never agreed with any of these warnings.
It's a bit
And then
late
you're like,
now.
there's nothing anybody can do, but they'll say, like, I never agreed with any of them. All these warnings they forced me to sign them, right? If you have a warning against your name, remember that it can affect your disciplinary record later on. If you come up with another charge and they want to dismiss you, they'll say, look, he's got 4 or 5 live warnings right now. They haven't expired. So you must challenge them. You must challenge them at the CCMA if you feel that actually I'm not supposed to have these warnings at all.
Now, one of the issues I think that we sometimes stumble over when we are, for instance, in a situation where we're fighting with our employer or there's some sort of, not getting along that's happening, is because we are so emotionally involved in the particular issue that we're facing with. If we're being discriminated against, it's incredibly emotionally taxing, and you're so deeply invested that we get caught up in the fairness of an issue as opposed to the legality of processes. So what is the relationship between morality and legality within the workplace?
I mean, often employees are quick to say there's a vendetta. These people hate me. They're out to get me. That's not the point. So that might be true. That's the painful thing. It might be true that everybody at your company hates you and they in fact have trumped up these charges. That's the reality. But the question becomes, did you do it? Did you do this thing or did you not do this thing? So it's very important that employees try and focus on the issue at hand. Focus on what they've been charged with. Focus on the nature of the dispute. It's not going to assist you to get to the CCMA and talk about a thing that happened 10 years ago, because that's not why you were dismissed. You were dismissed for something you did last month or you are alleged to have done last month. So it's very important for employees to focus. Ultimately, the legality in labor issues is fairness. It is about fairness, but fairness has very clear legs. The 2 legs are procedure. We talked about the disciplinary hearing, so procedural fairness. And the second leg is substantive fairness, the reason for the dismissal. So if we're talking about a misconduct, they're going to have to demonstrate that you committed the misconduct. If you're talking about poor work performance, which often comes up in issues where there might be some victimization, they're going to have to demonstrate poor work performance. They're going to have to demonstrate trying to train you, trying to help you improve. They're going to have to demonstrate those things. So it's not, at that time, it's got nothing to do with somebody who asked you to make him coffee 6 months ago. It's got nothing to do with that. You need to focus on what is at hand. Did you perform? Was there a clear standard that you didn't meet? And is that why you were dismissed? So those things are very, very important.
Now let's talk about remuneration.
Yeah.
There's so many. So we have equal pay for work of equal value, right? And I want, before I give you a chance, I want to just talk about that as what exactly that means legally. But at a deeper level, when you're looking at it from the context of the various levels in which it impacts on us, or that we interact with, that that discrimination that could occur there, from being recruited to whether or not job posts or job ads should include the salary to avoid discrimination, to if we have it in legislation, how is it enforced, and how are organizations held accountable if everybody is forced to keep their salary a secret? And
Mm.
are people actually legally forced to keep their salary a secret? So that's all my questions in one basket for you.
This is such a big, huge question. It's so hard. but the reality of the remuneration issue is indeed it is supposed to be equal pay for work of equal value, and we know that that is not something that is easily enforced. There is nothing that says you're not allowed to discuss in law that you're not allowed to discuss your remuneration. You can't look for someone else's. So if we work in the same organization, I can't go online and be like, how much does she earn? I can't I can't do that.
Right.
If we talk about it over tea, that's different. The irony is that most people don't like to talk about it because they don't want to know that they get less money than other people. I think people just don't want to discuss it because they don't want to know the truth. Because it's very uncomfortable, because then what do you do? And it could amount to an unfair discrimination issue. There are all kinds of things that employers do to justify different pay differentials. So it'll be things like, this person has worked there longer, despite the fact that you're doing the same work. They've worked there for this amount of time. So we place them on this end of the scale and you on this end of the scale. Or this person has, a certificate that you don't have, or a diploma you don't have. You two have the same LLB, but they did another diploma later on in life. So it justified. So there's all kinds of reasons that people give to justify that. It can end up amounting to an unfair discrimination issue. It can, but as you rightly said, it's very difficult to prove. It's very difficult to know for sure. I mean, it's very difficult that it's very unusual to have two employees that are identical in profile. And it makes complete sense that they should be paid the exact amount of money. So those kinds of issues, I wish I had a clear-cut answer for you, but I think it needs to be, it kind of needs to be a social discussion and a social movement to say, let's get open in relation to remuneration. I mean, even things like when you go for a job interview and they say, bring your last pay slip. That's none of your business. I mean, I'm asking for what I'm asking for. It's got nothing to do with you what I was being paid before. But they wanna, they wanna lowball you. That's actually what they want to do. So even that, I mean, in those situations, you can certainly say, I'm not going to provide my pay slip, but you risk not getting the job. So that is I think the beast that is capital. That's the unfortunate thing you dealing with when you're talking about a capitalist society.
Absolutely. And then there's also then the issue of, you're in your job and okay, you're not having any real issues per se. But you keep getting more and more work given to you, right? Oh, you're doing a fantastic job, so we're going to give you more responsibilities. And the work keeps piling on, but your salary doesn't increase to match the work. Your job description is not amended to what is now required of you, but your KPIs somehow relate to that. How can people navigate those conversations in a way that is coming from an empowered position?
So the issue of job description is sticky, because a lot of people believe, you're married to the job description. So to an extent, an employer can reasonably go outside of the stipulated scope of a job description reasonably. So if I'm just trying to think, if maybe in my teaching, I currently teach one module a semester, and they say, we're gonna add a module, and we're not going to pay you more. That's the reasonable extension of my work, to teach more. And it might overburden me, but it's within the scope of what I do. So it's difficult to say people should be married to their job description. That's the first thing. And in terms of navigating that, it's really not a legal question, unfortunately. It's very much one that will relate to negotiating with your employer and seeing how far you can get. If it becomes an issue of harassment, that's when it becomes a legal issue. If you become overburdened, and if
Mm,
you, it's too much, I'm being oversaddled with this, I'm being overburdened, then it becomes a legal issue. But before that, it really is a
mm,
discussion. And in situations like that, I would advise people to leave the organization, because I mean, if people want to take advantage of you, they're going to take advantage of you, and they know that
mm,
there's very little recourse in that,
mm,
in that set of circumstances.
mm. Okay. Now, one of the things that often comes up when we're having conversations about workplace issues or the experiences of Black professionals within the workplace, regardless of whether you're private sector, public sector, NGO,
Mm.
whatever the case may be, but particularly private sector, when there's a call for people to openly share their experiences, a lot of people will respond and say, "Our employers are watching us."
Yeah.
There's like this unwritten gag order that exists that we all know about. Nobody tells you don't say anything, but everybody understands don't say anything.
Mm.
And a lot of organizations hide behind either a social media policy that is put in place to supposedly protect the organization from reputational damage. But in many instances, when employees have a hard time at the work in the workplace and they're not getting, satisfactory support, or they go through all of the various channels and nothing's working out, and that frustration then leads to a vent on social media to say,
Mm.
I'm having a horrendous time at work. I have an abusive boss, this, that, and the other. But in all likelihood, that there will be repercussions for them in that aspect. So,
Yeah.
how can people navigate that? Because what are the parameters around things like social media policies and what you can and can't actually say?
Yeah, ultimately, it's a common law question. It's not something that sort of came only with social media, but the
Mm,
issue is whether or not you're bringing your employer into disrepute. So in employment relationships, some of the underlying tenets are things like loyalty to the employer. So that's why,
mm,
for example, you're not, you're not allowed to work for a competitor. They don't have to write that in your contract for it to
mm,
be a tenet of your employment relationship. So even things like not exposing the employer to reputational risk, that doesn't need to be in an employment contract for it to be a term of your employment contract. It is what we call a common law term of an
mm,
employment contract. It exists, whether or not we wish it to be there. So the challenge you're going to face, and it really comes down to a very basic principle in law we call audi alterum partem. And I'm sorry to speak Latin, I hate Latin, but
You lawyers, hey man.
but the value of that well, the idea behind it is that you've got a right to be heard. So if you throw an employer under the bus publicly, if perhaps you have not considered all of the channels internally to, you've not done the things you're supposed to do to complain, have you adequately given your employer a right to respond to your issues,
Mhm,
before you've taken them to the streets,
mm,
basically, and created obvious reputational damage? And of course, if you're complaining about a specific individual, you risk a defamation lawsuit coming from that person.
mm,
So all of those issues, I would advise people to never rant on social media about their employer. It won't get you anywhere. And I mean, the pain, it really won't get you anywhere. The unfortunate thing is that people look at, we're on social media, people will talk for a week or two. Hey, it's bad what happened to that chick. And then they'll forget,
yeah.
and no one will hire you. So and people will remember you for that thing and not the quality of the work that you're able to produce. And you will have a tough time in your sector carrying on. So the best thing people should do is follow the channels that are available to them in law.
Mm. I know it's a very difficult thing to hear for so many people because, again, it's that issue of, but it's not fair, right? And it's
Yeah.
not, right?
Yeah.
Ethically, it really isn't in most
Yeah.
cases. But yeah, no, I've had my fair share of dealing with legal issues, and I'm just like, none of this makes sense. I hate it. I
Yeah.
hate everything, and I hate everyone.
Yeah.
If you have any questions, guys, please do post them in the comments, and I will we'll address them here. There is somebody here who said that they have a social movement in place called payslipban.co.za. And essentially, they believe that job adverts must always reflect the pay range that is on offer, and that they shouldn't ask for a payslip or your previous cost to company, as this leads to labor price fixing. they find that their respondents share experiences where 6 months down the line, they realize that they are paid 3 times less than their colleagues who have different skin colors, so different races, right?
Yeah. Yeah.
Um, a lot of us know. I personally know this experience as well, and
Yeah.
it gets very challenging because when I discovered this, I was literally in the throes of grievance procedures, and I was told by a black HR person on the sly, how does that help me? you know
And
so you're
I
telling me
think,
this information just so that I'm frustrated and there's nothing I can do about it, because they can organizations will just be like, we don't know what you're talking about.
yeah, and
Everybody's
HR,
within this percentile.
yeah. Look, I mean, HR, it's such an unfortunate thing, and I think that HR really needs to be empowered. People in HR need to completely change the way they see HR, because currently HR is just an arm of management, and that's not what HR is supposed to be.
Mm-hmm.
And HR, I mean, those very HR people who say they've got your back, they'll come and give evidence against you there at the CCMA.
Hi, Ole. Shout out.
those, those very people who say they got you, they don't got you. So it's very unfortunate that they ultimately work for these people. They get their pays, they get their employees just like you and I. So what is
Mm,
really the point of HR if it doesn't defend the interests of workers?
right.
And HR, I mean, a lot of HR will just sort of say, pay them off, let's just offer them mutual separation. Let's
Nuisance
just
pay.
yeah, a nuisance
When
value.
I heard that term from a lawyer friend of mine, they're like, oh, it's just nuisance pay for them. I was
Yeah.
like, what?
You're irritating me. You're a nuisance. And that's a real thing. Offer a nuisance value. We're willing to offer a nuisance value of a month. So it's a
It's
very
ruthless.
and then that's a very, very real and painful. And I think, and I often say this to people: you gotta, labor disputes. You gotta take your heart out, and that's the most difficult thing about it, that it's extremely personal. You spend time at that organization, you
Mm-hmm.
spend 8 hours a day there, you give those people your life, and they are
Mm-hmm.
so quick to replace you and throw you
Yeah.
out. That's why it's so hurtful what happens. And
Mm-hmm.
that's why, when employees get to external dispute resolution forum, they are so bitter and so angry, and now they want 24 months salary, and they they want everything because they're just mad and
Yeah.
hurt.
Yeah.
But the reality is, and I often say this, you don't want to end up being crazy 10 years from now from this dispute. I mean, I used to volunteer at a center that dealt with labor issues when I was a candidate attorney, and we'd get people there coming to the labor court to deal with their disputes, and they got a file like this big, and you ask them, when were you dismissed? 2003. You're just like, yeah.
What?
And they're still fighting, they're pushing, and you can see this person has now gone a little bit off the rails because this case has driven them crazy. so
Mm-hmm.
so I don't always think it's worth it. I often say to people, cut your losses, go to the CCMA, fight your disputes, deal with it, try and settle it if you can, and move forward with your life, because you don't want to be here 10 years from now
Mm-hmm.
fighting these same guys, not able to
Mm-hmm.
move on with your life because you spend all your days chasing your case. um
Absolutely.
yeah, it's
Absolutely.
it's it's really not worth it.
Absolutely. I remember a few years ago, I applied for a job, went through the whole recruitment process. I was hired for the position, and then I was fired on my first day of the job before I even started, like as I arrived, because of discrimination based on some other issue that was completely unrelated. Um, yes, we settled, but also that was a decision that I had to make to say, I don't have what is going to be required for me to go through an entire legal process. So I'm
Yeah.
gonna take what I'm gonna take now, and the rest will have to just work itself out, because you have to make that choice:
Yeah.
sanity or trying to prove a point. And sometimes sanity is what trumps everything.
Yeah.
There's a question here from the Javis. Temporary layoff. Does an employer have to follow the exact same process as a full retrenchment process? How different is it? And what are your rights while you're temporarily laid off?
I can't believe my own blood cousin would ask me this question. That's could ask me in private. but
Traitors are everywhere.
I'm telling you. But in essence, you need to follow a process relating to some sort of consultation, some sort of discussion, because that is a common thing that's happening now. Temporary layoff in light of COVID-19.
Right.
Now, the idea with temporary layoff is that you do not get to full dismissal. It's not a dismissal per se. It's to say, okay, you're gonna not work for a month because of this situation that's happening. The interesting, I mean, to be honest, a lot of these issues around temporary layoff and actually COVID-19, it's going to be new even for lawyers, because we've never seen situations like this. And in terms of what will be required in relation to fairness, I think that when these disputes start to arise, we're going to see issues. We're going to start creating different systems around fairness, because it's not exactly like retrenchment, but it's akin to it, retrenchment. And I think employers are going to start to have to be able to show that they, for example, applied for TERS. You know, some people are doing temporary layoff. They've never applied for the temporary relief scheme. And they're not taking advantage of the benefits that government is attempting to provide. They haven't even tried. So those types of things will point an adjudicator in the direction of unfairness, to say it doesn't appear as though you are genuine in your need to lay off if you didn't seek the assistance of the state. So those things are a bit novel. It's difficult to answer. I'll answer you later. but those things are a little bit difficult to answer because they're not clear cut as yet.
Okay. Let me see if there's anything else I wanted to cover with you. We've covered so many things.
Maybe you want to talk about poor performance a little bit more, because
Yes,
that's
we've got about 5 minutes left in this
yeah.
live. So yes, poor performance,
Yeah.
please.
So that's often used as a bullying tactic to
Yes.
question a performance. So it's very important that an employer has a clear standard. Okay. So even when I've talked to employers, it's important to create some sort of a rating system where employees come every month or every quarter to, and this is what you score, this is what we expect of you by this time, and this is what you scored as a result. Consecutively 5 times you've fallen below 3, and therefore we are moving towards performance management. So it's quite a process. It's not a question of I didn't perform for a month, I didn't earn fees for a month. It's quite a process that an employer is supposed to follow. They must set out a clear standard for the performance, and you must have fallen below that standard consistently. They must also demonstrate that they've attempted to help you reach the standard. So that can be more training, more assistance, more guidance. And let me say very clearly, this even applies in the probation period. Sometimes people think that they can be dismissed fairly just like that within a 3-month probation. It's not like that. It's the same issues must apply during the probation period as when you have gone beyond the probation period. So I think that's very important.
Will pay slips ever be banned? Is there hope?
And we need them ultimately. I mean, later on, we need them all over the place. We need them, but when an employer doesn't provide a pay slip, it's a big deal, because you can't see where they're taking money, where the money is going to. A pay slip binds your employer also. It shows you, this is what I've done with your money. Sometimes an employer will deduct UIF, they never pay UIF. But now you've got a pay slip saying they've been deducting. Yeah.
We've all heard about that.
Yeah. I wasn't going to go there, but yeah.
So the issue of poor performance, right? Because obviously this performance thing is something that's often used in constructive dismissal. And I speak from personal experience where, I had literally out of nowhere a boss who's suddenly, campaigning with people to say that I'm a non-performer. But fortunately, I used to document everything. So they could never actually do anything, because I was always very intentional about making sure that I have feedback from my stakeholders in writing, that they're all happy with the work that I'm delivering, that I always have that correspondence. So I was able to say, if you're saying I'm not delivering, what is it exactly that you're referring to? Because here's evidence that says that all of my stakeholders are happy. So which ones are not happy? So how important is it for people to be proactive about also managing their own performance and their own careers within the
Yeah.
workplace.
It's critical. And I think generally speaking in an employment relationship, it's so important for all of us to take responsibility for how we're interacting with colleagues, with our supervisors, with external stakeholders, because all of those things really, they either detract or add to your employment relationship and your ability
Mm-hmm.
to defend yourself down the line if you need to defend yourself. And even
Mm-hmm.
if nobody in your organization can say we're happy with their performance, look at how many people externally can say they are happy with your performance. So
Mm-hmm.
those kinds of things are really, really critical. People must take responsibility for managing those relationships within an organization and externally from the organization.
Awesome stuff. Wetra, we did cover the issue of pay slips when you are in the recruitment phase.
Yeah.
Um, you don't have to, but there's a risk that you won't get the job. But
Yeah.
you know, it's not a legal requirement. So
Yeah.
we did cover that. Thank you so much, Kgomotso, for this conversation. So valuable. I will be saving it. It will be available on my IGTV, so you guys can always go back and have a look at it. Please also follow Kgomotso. She's just like a wealth of knowledge. She also does webinars every now and then that you can sign up for. So just keep an eye out for that. Thank you so much for joining us for this session. It's very educational to always learn about the law, but also very frustrating because we're very emotional, those of us who are not in the law. So this is very hurtful. A lot of the time, I don't know how many times I've had conversations with friends and be like, okay, so this is what happened. I have grounds, right? And they're like,
No.
actually.
No.
And you're
Sorry.
like, what do you mean?
Yeah.
No, that's not what I want to hear. But yeah, it is what it is. So I've
Yeah.
learned to be a lot more strategic about how I approach these issues because that's honestly what the law requires you to do. Take emotion all the way out of it and focus
Yeah.
on the facts of
Yeah.
the issue. So
100%.
thank you so much and have a
Thank
wonderful
you.
evening, everyone.
Thank you. Cheers.
Bye.